Well, good afternoon, everyone, and welcome back to for those who were there present for our first presentation. We are on a journey, and we are looking at we are working our way through the full sweep of employment law, and today we are exploring the key issues of contracts and policies in the space of the next hour. So they are absolutely at the heart of the employment relationship. For a long time, employment contracts were very dominant, and now probably in the last 10 or 15 years, policies have really exploded within workplaces and have become increasingly vital in ensuring that staff or that employees that they will carry out or achieve the outcomes that the employer requires them to do so. So they've become a whole new world. But today I'm going to be speaking to you about the employment contract, and my colleague Alex will be talking to you about policies on the back of that. So the employment contract is, if we can, in the grand scheme of the sweep of the presentations we're going to do, we are Alex, if you want to show the next slide. You'll see that this is the second in our presentations, and as we move on further through exploring different rights under the Fair Work Act, we'll go on to look at the issues of misconduct and performance, and the termination as a result of that, dealing with ill and injured workers, the challenges of restructuring, and of course the questions about how do you protect your business from your aberrant staff member. So, as I said, today we're looking at the questions of contracts. So the question is why? Why does it matter? Well, contracts are about risk allocation. Essentially, we're paying people to carry out various duties for us, and we have to define that relationship in some way, because businesses, they own the plant and equipment, and they have clients, and they are contracting out into the world, and they need assistance to get the job done. So at its heart, the employment contract is the way in which employers ensure that employees do what is required to achieve the outcomes for the business. It also makes it clear whose job is, where responsibility lies. Does it lie with an employee, or does it lie with an employer? And don't forget, and that's done in the context of our prior lecture, we looked at the question of awards. Awards tend to be generally structured to set minimum entitlements for employees. So contracts are an opportunity for a business in a way to push back a bit and to define for that business how it's best going to work in their dealings with that employee. In the issue of policies, which Alex will talk about, that's a lot about trying to ensure that the business stays on the right side of the law. There has been an absolute explosion in legislation around the employment relationship, and it exposes businesses increasingly to huge risks in relation to penalties, and both within the work health and safety area now and within the Fair Work area, you've now got exposure even in relation to prison sentences in the most extreme cases. So policies are really fundamental for businesses to keep some level of control over, or to bring some shape to the business to ensure that it's not unnecessarily exposed. And then on top of that, you'll have the culture within a workplace, which will define how people act within the workplace. Now, that is both shaped by the contract, by the policies, but also by more ethereal ideas of leadership and behaviours within workplace and what's tolerated and not tolerated. So how does that look within the context of a pyramid of different sources of law? So we looked at the National Employment Standards. Now, they are the fundamental standards that all businesses have to comply with. And we then looked at modern awards. How do they apply? Well, they apply because they apply de facto. They just apply. If you employ someone, then the National Employment Standards will apply to them. If you employ someone and they're covered by awards, and that's most employees, then they just apply. Now, what happens if you don't comply with either an award or a National Employment Standard? Then the remedy is fairly significant. It's whatever loss may have arisen. Furthermore, it is whatever penalty that the federal court chooses to impose upon the business. And increasingly, those penalties are up towards $1 million for a standard breach for an employer if they breach any of the aspects of the National Employment Standards or indeed the awards. The employment contract is different. The employment contract is a peer-to-peer relationship. One entity, one employee. So that's a very different type of relationship, and it only applies when you employ someone in a written form. It applies when the employer provides an employment contract to an employee. And we'll talk a little bit about that as we move forward. But it also applies even if no contract is given. It makes it more difficult for the parties to discern what exactly is the contract. But in every employment relationship, there is deemed to be a contract. And if the contract is not in writing, then the contract will be what was discussed or could be inferred from discussions at the time as to what was the agreement between the parties in relation to the various aspects of that relationship. So what's really important for employers is, in fact, to have a written contract, because if you don't write it, then you're really leaving it up to the court to decide what that contract looked like. So the contract, a written contract, is an opportunity for an employer to define those terms. Now, these days, most employers will have an employment contract, but for some employees, that will be fairly short. The form of the contract may be a series of standard terms and conditions, and it may be a letter of appointment just dealing with certain specifics to do with when someone starts, the status of the relationship, how much they're going to be paid, et cetera, et cetera. And they'll refer to the standard terms and conditions for that particular business. Now, that's fine. That's a reasonable way to approach it. But employment contracts tend to look different depending on whether or not you're dealing with someone who's on the shop floor or someone within the senior management team. So the features of an employment contract are, the first thing is it's a contract. Now, there are, as I said, if you are in an employment relationship, there's deemed to be an employment contract. So it's generally speaking inferred that would be the case. But sometimes there's real questions as to whether or not there may be an employment relationship. And that's tied into this question of a contract. But just for the record, there are basic elements that form a contract. And there are 6 elements. There's offer, there's acceptance, there's what's called consideration, there's the capacity of the individual to in fact engage. So someone who didn't have mental capacity, for example, would not be able to enter into a contract. The next feature of it is the intention to create legal relations. Now that's inferred if you're going to employ someone. And then the final one is clarity of terms. And that can bring a lot of people undone and certainly creates work for us when people do not take the time to properly draft terms of a contract. So once you've got a contract, then what are the fundamental aspects of an employment contract in particular? And there's really about 6 fundamental aspects of the employment contract. And they are, Alex, thank you. The 6 basic elements of the employment contract is who is the employer, who is the employee, and we'll talk a little bit about that. What is it that you expect the employee to do? How much you're going to pay them? What are the hours expected of them? Where is the work to be done? Now, once upon a time, that was pretty clear, but increasingly, with work from home, etc., that's becoming less clear. And of course, the length of the engagement. Is it for a finite period, or is it does this arrangement run on? They are the 6 fundamental elements that you need to get right in an employment contract. If you don't get them right, then it can really bring a business undone. So the way I'm going to explore the contract is I'm going to do it by, we're going to work our way through. So with our help portal, which is our tool for delivering materials for our staff and available for users, we actually have a function that helps you build your own employment contract. And we're going to be using that today as the way of exploring the different elements and questions and considerations that go to drafting a contract. So the first aspect of that is looking at this question of who are the parties in this, who are the parties to the contract. The law has not moved from the position that there can only be 2 parties in an employment contract. That if you've got a partnership, arguably there will be multiple parties as the employer, because that's the nature of a partnership, but there only will be one employer. And so you would think that would be a pretty simple question, but often employers don't get that as right as they should. And it can have really significant implications if you don't get that right. So the key aspects of identifying who is an employer, who's the employee, and nominating the correct employer as well, is that you can end up with a situation where it's for an employee. The question is, who do they actually, if it goes wrong, who do they sue? But where it becomes really problematic for businesses is around the question of, particularly around questions of protecting the business. If you've got a employment relationship within a group of companies, and that's not unusual, even in private companies, non-public companies, often you will have multiple companies. You might have a company that's a service company, and that employs all the staff. And then, but you'll have a separate business, which is the principal business, which actually engages all of the clients. You may even have another entity. This is what sometimes happens, where if you have really critical information pertaining to a business, which is really vital for its operation, that may be held with another company. If you draft an employment contract and it's dealing with questions of confidential information, and the employee is only employed in the context of by a service company, and you've got a clause in there which says, the employee has to respect confidential information of the entity, and it sort of lists all that sort of features of which would be comprised in that. But that confidential information is held elsewhere, or indeed, if you have an intellectual property clause regarding trademarks, etc., sometimes they will be held in a parent company, or indeed sometimes you'll have situations where a company will hold a trademark or certain intellectual property for a third-party superannuation fund and only make it available on license. So it's important to understand where the value in the company and where the confidential information lies. If the client database is owned by another company within the group and your employment contract doesn't take that into account, then arguably the employee, when they leave, they can harvest that database, what they can remember of it, they can access it, subject to various intellectual property rights, but they are not in breach of the contract if indeed they were employed by a service company. So it's fairly important to understand where the value in the business. So, for example, if you've got a confidential arrangement with a group of company and the client list lies with another entity in the group, then you need to specify that in the employment contract that we're talking about confidential information held by another company within that group. So that's why it can be really important. And that also is doubly important when you're talking about post-employment restraints. Again, if you want to talk about a competitor to a company, well, if the individual is only employed by the service company, then that service company doesn't have any competitors really. And certainly if you want them not to contact clients, and that client list is those clients are held by another company within that group, then again, you won't get any protections there. So it's really important to understand who you're employed by, and secondly, where the value in the business is, and draft the contracts appropriately. Now, there was a case involving that went to the Court of Appeal some time ago, about 4 or 5 years ago, that I was involved in. And one of the questions that came up in that, it was someone who's employed under a contract, but most of their time was spent working for another company within that group. In that situation, the court found that notwithstanding that much of their time was devoted to another company within the group, and indeed they were paid out of another entity, and even a third entity within that group, notwithstanding that, the company was found to be, the employer was found to be the entity that they signed a contract with. It was not found that the contract didn't serve that function. So that's another situation where you can have confusion. So it was found that the employment contract was the dominant feature to define the parties within that relationship, even though their time was spent serving another entity within that group, even though they were paid by an even further entity in that group. It was still found the employer was the employer pursuant to the contract. So getting the parties right is a critical issue. The next aspect of an employment contract is this feature of how are you going to, what's the nature of that relationship of the employment relationship? And there are well-defined features of well-defined types of relationship within employment space. You've got full-time employees. You've got permanent employees which cover both full-time and also part-time. And to kind of confuse the issue, you've also got fixed-term contracts, and fixed-term contracts will they can be, again, full-time or part-time. And there's different types of fixed-term contracts. And then, of course, you've got a casual agreement. Now, there's been changes to the Fair Work Act to set out certain criteria by which the court will consider whether an arrangement is a casual or a full-time. And the Fair Work Act even contemplates people who work very irregularly as casuals and also more regularly on a regular and systematic basis, but they still remain as casuals. So when we're using our help program to produce, define the contract, Alex, if you want to move on, the sorts of questions that we're asking in that regard are how do we want, with the casual employees, what are the advantages of opting for that particular status is that with casual employees, of course, you don't have any sick leave or annual leave, but you do have, they do have a right to long service leave. With casual employees, you have all the normal on costs, workers' compensation, superannuation, etc., and even payroll tax where it's applicable. And then there's a separate question, I guess, which is relevant. Are you going to put them on a regular roster? Now, why that's significant is that if you put them on a regular roster, then after 12 months, they've got the opportunity to make a request so that you can transfer them to be permanent employees, or rather full-time and part-time employees in particular. So that's if they're working a regular roster. There's also relevance around whether they're working on a regular and systematic basis as to whether or not they're entitled to unfair dismissal. So if an employee that's a casual is working very irregularly, then they're not entitled to make a claim for unfair dismissal. But if you have a casual employee that's past the minimum employment period, then they're entitled to make a claim for unfair dismissal if they're terminated, like anyone else. One of the issues, I guess, that arises with casual employees is the question of how do you actually terminate a casual employee? Well, a casual employee, because often people will just reduce their shifts. And so it can, or they may not have worked for a long period of time. One of the features of a casual relationship, and it's important to understand, is that they can refuse to work if they can refuse work if they want to. So where's all this leading? Well, what it means is that it's important to understand what you want out of that particular relationship. So if one of the reasons, if you're going to be paying a 25% loading, which is applicable for a casual arrangement, then when you're paying them a permanent part-timer only for annual leave and sick leave, which is worth about 11 or 12%, do you really want to pay the margin if they're still going to work on a regular roster? So I think it's important to understand what are the benefits you want to achieve out of having this relationship. Alex? So one of the issues about part-time employees, you can consider that, and it's important to understand it under the award. With part-time employees, if you want to increase, first of all, you have to define their hours pursuant to the awards. It's very clear. Most awards say that you've got to define the days they work and their specific shifts that they're working. It's got to be in writing. If you want to work beyond that, then you can ask them to work at normal rates. But if you direct them to work, then you generally, under most awards, have to pay them overtime. So that's an important feature as you're making this decision in your employment contract. And there was a recent case which said that when you want to, you're asking them this question about whether they want to work overtime, and if they agree to that and it's in writing, then you're paying them ordinary rates. But there's the court last year, in the federal court last year, said that you need to explain in that situation the context to which you're doing that, including that if you gave them a direction that they would be entitled to overtime, which was fairly annoying that the court made that point. But so it's important to understand when you're dealing with part-time people, making that consideration. If you want them to be quite flexible, then that may be problematic. Now, obviously, the next status in this area is whether or not you want them permanent or you just want them for a fixed period. So the notion of a fixed contract was originally you would have contracts, and there's still features with a lot of the time in sporting environment, people just work for maybe for a year or so. There's another form of fixed term agreement where it's basically specified for a year, but during that period, either party can terminate. That's called an outer limits contract. Otherwise, a permanent contract, as you know, will roll on until you terminate it, and that termination can be subject to, for example, unfair dismissal claims. It's been held with fixed term agreements that if someone is employed for that period, and at the end of that period, it just expires, that's not considered to be a termination for the purpose of unfair dismissal. Now, one of the issues that's arisen, the changes to the Fair Work Act recently is you cannot have multiple fixed term agreements that run beyond 2 years. Otherwise, it's a breach of the Fair Work Act, and that it actually can lead to a civil penalty, but they're also unenforceable. So just be aware you can't roll on. There's certain exceptions to do with charities and academic institutions, but by and large, you have to be mindful that fixed term contracts, you only do them for up to 2 years. Okay, so when you're drafting a contract in our help, we ask that specific question is because often you will issue an employee who's employed under an employment relationship over a long period of time. They might have multiple contracts. They may actually move from casual to part-time to full-time, and each time they'll have a different employment contract. But even within full-time, if they get promoted, they will have often a different employment contract. So we make the point, why is it important to identify that? Because it's important for a couple of reasons. One is the question of when that contract is going to commence. So, and also it's probably worth making it clear within the contract that they've got a history which may go back a number of years for the purposes of continuity of service, which shows up in such matters as a long service leave, or even indeed the accrual of personal leave and annual leave. So it's important to make the distinction between someone who's starting. I will say quite quickly on this issue, if you give an employment, there's two important things to understand about employment contracts. If you give someone an employment contract and ask them to sign it and they refuse, you can't make them sign that contract. The second thing is, if you give someone an employment contract and they do sign the contract, but there's no increase in salary or there's no benefit given to them, then it can be often the case that that contract will not be effective or binding upon them. The law gets a little bit, there's this idea of practical benefit which comes into play, which confuses the issue. But it's if you want to give someone a new contract or introduce new terms into your contract, the time to do that is when you're going to give someone a pay rise. That's so they actually get, because one of the features of an employment contract is consideration. So it's I'll say it again. So if you give someone an employment contract and all it is, for example, introducing a post-employment restraint, which wasn't there, they sign that agreement, they continue to work, then there's a real prospect that that restraint will not be found to be a valid term, because the contract variation will not be found to be valid because there wasn't consideration, there wasn't a benefit which flowed back to the employee. Just when you're starting and most people do this, but please send out contracts before people start so that they've seen the contract beforehand. Because if someone starts a job with you and then a day, even at midday on the first day, if they gave you if you give them a contract, and there's no benefit to them, it's the same salary that they knew of beforehand that may have been set out in some letter, it may well not be binding. So it's important that people get sent contracts before they commence. So now we build into help different set of questions for senior employees, because with senior employees, there can be a range of issues that arise that may have different benefits, bonus, etc., which we'll talk about. But also the issues around conflict of interest are a much more significant issue for senior employees, and generally speaking for restraint of trade, that will be enforceable for much longer periods of time for senior employees. So in our contract builder in the help portal, we've built a series of questions around that, which lead to a more robust contract for senior employees. So the probation period, we have also built into the contract, but it doesn't really serve a purpose. It's more cosmetic. It's probably the only term we've got in there, which is arguably cosmetic. Probation really came out of this idea of a period of time when you couldn't commence, when an employee was not entitled to access unfair dismissal. Of course, that minimum employment period is now built into the Fair Work Act. So that's no longer a probation period clause. We build it into the contract because people kind of like it, but it's not necessary. So one of the questions that often gets asked me, if you're going to terminate someone within a probation period, and I'll deal with this a bit later on but my view is you don't give them an opportunity. In my view is, and it sounds terrible, but you don't even sit down with them and give them a warning. My experience is as soon as you do that, it can be quite often the case they may go on workers' compensation, and it makes the whole world much more difficult to deal with. If it doesn't working out with a employee, can I suggest you go and simply speak to that employee, tell them that it's not working out, and finish the relationship there and then. It sounds brutal, but it's unfortunately in this day and age necessary. It's important to understand, and we build it into our series of questions, the questions of award coverage, because if there's award coverage in a contract, if there's an award coverage for a position, that will impact upon such matters as allowances, as overtime, and as penalty rates. It may not always be understood, but if you're not award covered as an employee, then you're not entitled to be paid overtime. That is when overtime an elevated rate, time and a half, double time, etc., and you're not entitled to penalty rates. There's just a flat rate. So it's important when you're drafting a contract that you get that clear. Specifying that someone's covered by an award doesn't make them covered by the award. So you need to arrive at that, and we talked about that on the last occasion, at that decision independently. That's defined by the award and the nature of the business, but it's helpful to specify it in the contract because it makes so that you're clear as you're drafting it that you will have these obligations to meet. Confidentiality for most people will be a boilerplate clause, but if you've got particular clauses so we build it in because we ask the question to employers, is there particular information that you want to treat as confidential? And so we suggest that you specify that within the contract. Just a basic view, if as a business you don't do this, you don't specify it in the contract, and you're otherwise lackadaisical about confidential information, the court will not support you in relation to such a claim. The other issue in relation to employment contracts, or one very important issue, is this question of notice periods. So just a couple of quick points on notice periods. It's important to think this through. If you give a long period of time to an employment, you require an employee to give you an extended period of notice, that is a bit of a deterrence to them just going in and getting another job. The downside of requiring that is if someone is not working out and they're not performing, then and they get the hint and they leave, then they'll give you an extended period of time. You don't want them hanging around because they're causing issues for you, and you're going to have to pay them for that period. If they're a good employee, requiring them to have an extended period of notice is important, because often by the time they give notice, you'll need to advertise for a new staff member, or at least, and that can take some time, or at the very least, you'll need to train up another existing staff member. So having a handover period, so it can be advantageous to have a longer period of notice in there for a staff member who is quite important to you. It also is the best protection from them starting work. They simply can't start work elsewhere if they're serving out a period of notice. You've got to pay it to them, but they can't wander off. And so it's more powerful a term than a post-employment restraint. So I know some of my clients will have a 3-month notice period that employees will have to give. Likewise, in relation to employers giving notice, if you're an employer and you're giving notice and they're not performing, you don't want them hanging around for an extended period of time. So having a long period of notice that you've got to give them, you're ending up going to have to pay them that notice. Either have them sitting out on notice or just pay it to them in lieu. So understanding clearly the notice period that's going to work best for your business and best for that employee is really critical. It's not simply a boilerplate matter. It needs to be thought through. Now, of course, these notice periods have to be at least the same or more than required under the Fair Work Act. And the Fair Work Act has a requirement that people paid from 1 week through to 5 years, depending on their length of service and whether or not they're over the age of 45. But so that's an important factor to take into account when you're drafting that. Commissions and bonuses, just very quickly. Commissions are, generally speaking, a contractual term which will be defined within the contract. It's a formula that will sit there and will often be direct representative, a percentage of sales on a gross basis, but there'll be a formula that's applicable, and it will be buried within the contract, and it can only be changed with the agreement of both parties. Bonuses, on the other hand, are often discretionary, and the bonus they'll want to change it from year to year. So the guts of that bonus will sit within a policy, and the employer can change that policy. The bonus will be referred to often within the contract in a simple clause, which will say words to the effect of that you will be entitled to participate in the company bonus scheme when you have served 12 months. Your participation in there is subject to the discretion of the employer, or words to that effect. So it'll be a simple clause, but much of the bonus will be sit within the policy. Now, a lot of the time, people will specify that it's discretionary. There is, in fact, a case in that regard, which specifies that if it is a bonus, Alex, if you can go to that slide, where that it can't be exercised, that discretion cannot be exercised frivolously or unreasonably. There has to be a reasonable approach to exercising that discretion. Motor vehicles, that's another clause that you need to think through, and hence we ask a series of questions in our help portal to help step people through. If you're going to give someone a motor vehicle, what are they going to be responsible for? Are they going to be responsible for example, are you going to pay, are you going to give them a motor vehicle, or are you going to pay them an allowance? And given the nature of the vehicle you might provide them, questions get arised as to fringe benefits tax. So that has to be thought through if you're going to provide them with a motor vehicle. And I'm not going to give you advice about that, but the second aspect is what costs are you going to pay? You're going to pay fines, parking, petrol on holidays. Insurance excesses if they have an accident. What happens if they void an insurance policy? Do they have to pay for the entire cost of repairing the vehicle or the damage to the other vehicle? Important factors to be understood and set out there. Do you want to be able to take the vehicle back when they're on long service leave or extended periods of workers' compensation? It's important to define that within that. And then, of course, make it clear whether there's a right on your part to apply surveillance to that vehicle. We're going to talk about another critical aspect of employment contracts is restraints. I'm going to say an important issue. Often people come to us and say, oh, restraints, they're not enforceable. A properly drafted restraint in the right place is enforceable. They are very powerful clauses to include within employment contracts, but they have to be drafted appropriately to suit the particular employee. So I won't say anything too much more on that, except if you've got someone who's got access to vital information, then you probably don't want them going to competitors. If you've got someone who's going to have close relationships with clients, then you probably don't want them being able to deal with clients in the future. If you've got someone who is supervising, who runs a team, then you certainly don't want them to be able to recruit employees. So these are the features in the employment contracts. That there are several other matters that there are several other clauses that we deal with that will feature in our help program. We ask a range of other questions in building that employment contract, but I thought I would just explain, but I've just sort of shared with you some key features of the employment contract. So I'll allow in the remaining time for Alex to discuss policies. You're on mute, Alex.
Is it really a Teams meeting unless someone's on mute? Oops.
Okay.
Okay, well, thanks, Warwick. Yes, for the next about 10 minutes or so, I'm going to speak about the impact of workplace policies on managing staff and defending civil claims and prosecutions by Safe Work. I'm also going to cover off on some policies that we consider are the bare minimum that should be implemented in your workplace. Now, we would hope to take questions at the end, but we might run out of time. So feel free to put your questions in the Q&A section. And if we don't have time to address them, then we can come back to you after the seminar. So what is a policy? Well, a policy is a lawful and reasonable direction given to the employee or workers generally if it applies to subcontractors. If a person breaches a policy, they are generally not breaching the contract unless you've built it into the contract. However, a well-drafted and executed policy helps ensure directions are clear, consistent, and legally sound, sets standards of workplace behaviour, helps create a fair, compliant, and professional work environment, and assists businesses and organisations to manage risk, meet legal obligations, and promote a positive workplace culture. The drafting and implementation of a policy can have drastic impacts on an employer's ability to defend claims brought in any of the jurisdictions on the screen here. Under each of the categories of law shown on the screen, there is a different government regulator or commission that enforces those laws, and they all interpret the impact of policies in different ways. So I'm going to briefly walk you through how policies can be relevant in each of these jurisdictions and explain some learnings we can take from the case law and our experience advising in this space. So an employer's policies can be relevant to managing physical and psychosocial hazards in the workplace, as well as defending prosecutions from Safe Work New South Wales. For those who are unfamiliar with Safe Work's work, I say good for you. Perhaps that means you haven't had it run-in with them yet. But for everyone's context, Safe Work is the core New South Wales regulator of the Work Health and Safety Act. On the screen here, we have the foundations of work health and safety law in New South Wales, and it sets expectations for pretty much all participants in a workplace, but what's relevant to today is it sets expectations for employers. So the obligations start with the Act, they move down to the regulations, and then to your codes of practice. Your codes of practice are the most practical application of the obligations imposed on employers in the Act. Up until now, and as the law quite literally stands right now, a code of practice was relevant in prosecutions brought by SafeWork for a breach of the Work Health and Safety Act to the extent that it was evidence of information that was readily available to an employer that they could apply in their workplace to comply with the Work Health and Safety Act. From 1 July, that's going to change. There will be a positive obligation on employers to put in place a system that is either the same as or better than the codes of practice that SafeWork releases. So we are encouraging our clients to review their policies and systems of work now against the codes to make sure that you've got a defensible answer to SafeWork if they show up and start asking questions about your compliance with the codes of practice. On the screen here, we have just some of the examples of the codes of practice that you can find on the SafeWork website. By my count, there's about 47 codes of practice at the moment. One of the most relevant codes at the moment that comes up in SafeWork's spot checks of employers, bearing in mind they don't need a reason to show up to your workplace, but also when they show up to investigate a complaint, is the code of practice on managing psychosocial hazards. What SafeWork will do is they will show up, they will ask for a copy of all of your policies that relate to psychosocial safety, they will audit them, and if they're not happy with what those policies state, they could take enforcement action, which might look like an improvement notice, which means do it better within a period of time, a prohibition notice, which means stop doing this certain work until you can prove to me that you're doing it safely, or in the very worst case, they can commence prosecution as well. Now, why should you care? There are lots of reasons why you should care, and on the screen here are some of the more pertinent reasons. These are the offences under the Work Health and Safety Act that carry the greatest level of fines. So the fine for industrial manslaughter in New South Wales is the largest fine in the country. And you can see on the bottom left there, our point in red, the laws changed a few years ago so that it is now unlawful to insure against or indemnify a person for a fine under the Work Health and Safety Act. So an insurance policy might cover legal or investigation fees, but it won't cover the actual fines. And importantly, these offences can arise out of a failure to protect both a person's physical and mental health in the workplace. When you implement a policy that relates to work health and safety, the Work Health and Safety Act states that you are obliged to consult with your workers. So I put this here as a reminder that you could have a beautifully drafted policy to do with, say, bullying and harassment. But if you do not consult, meeting the obligations under both the Work Health and Safety Act and your own enterprise agreement or award, then that policy may not be enforceable and you could fall foul of your obligations under the Work Health and Safety Act, which brings its own work health and safety prosecution. Now, on to Fair Work Land. The Fair Work Act is dealt with generally by the Fair Work Commission and the federal courts. Considered in this category is also the Industrial Relations Act, which applies to public sector employers, but for the sake of today's presentation, we're just going to focus on the Fair Work Act. An employer's policies are most relevant in terms of the Fair Work Act when defending stop sexual harassment or stop bullying orders and an unfair dismissal claims. So stop sexual harassment and stop bullying orders are rarely sought because there is no money in it for the employee. But basically it's the employee seeking an order for someone in the workplace to stop doing something or start doing something, and the same for an employer. So part of that claim could involve the employee asking the employer to change their policies on something related to bullying and harassment. Unfair dismissal claims is where we hear about an employer's policies the most. They are usually brought up in the context of an employee's employment being terminated because they breached a workplace policy, and then the employee alleges that they were not trained on that policy, had never seen the policy before, or the policy does not say what the employer says it does, or that the employer has applied that policy inconsistently. So they say the termination was harsh, unjust, or unreasonable. The best way to explain how policies can let you down in a dismissal process and how we can take learnings from that is to explain it in the context of case law. So a case we've got here is a bit of an outrageous case, but it does serve the point. In this circumstance, Mr. Samad was basically engaging in sexual harassment against his colleagues. He was making sexually suggestive comments to his co-workers, accompanied by inappropriate gestures. His co-workers would complain about it or tell him to stop, and he would double down on that behaviour. The employer conducted an investigation, found that he had breached several policies with his behaviour, and ultimately terminated his employment. Now, this employee brought an unfair dismissal claim, and they also sought reinstatement into the workplace, which is a very problematic remedy to be asking for when you're dealing with an employee who, in this case, had shown basically no remorse for his behaviour. So if he got sent back into the workplace, that could create all kinds of problems. Now, this employee said as part of his defence, the employer terminated me because of a particular policy. I hadn't been trained on that policy, and if I had, I wouldn't have sexually harassed my colleagues. I'm paraphrasing, but that was basically his defence. And unfortunately, the Commission in this case said that's a really good point. If the employer had properly implemented their policies and the employee understood them, he might not have engaged in that behaviour, and so he was unfairly dismissed. Now, he didn't get reinstatement, which is probably the only good outcome out of that, but he did get lost earnings. So what we have on the screen here is the steps that we look for and supporting evidence we look for when we are advising on an employee's termination of employment that relies on a breach of policy. Ideally, we want a simple and clear policy that is easy to follow, so overly prescriptive policies can let you down. Evidence the employee was notified of the expectations in the policy and received recent training on them. Consistent application of the policy, so there isn't evidence of an employer picking and choosing when to enforce it unless there's good reason as to why. Evidence the employee actually breached that policy, which falls into that fifth category as well of conducting a fair investigation, and the employer can justify a fair and proportionate outcome to that breach. Sometimes in the Fair Work Commission's eyes, they might find that an employee did breach a policy, but that the appropriate outcome would have been a warning instead of dismissal. So that has to be part of our consideration. On the note of discrimination, policies are particularly relevant in discrimination law when you're dealing with claims like sexual harassment or any other claim under the Sex Discrimination Act. This is because an employer is vicariously liable for an employee or their agent's actions unless the employer can establish that they took all reasonable steps to prevent the employee or agent from committing the act. So we'll use sexual harassment as an example. So evidence of an employer properly training employees on their expectations not to engage in sexual harassment, properly drafted policies, attendance records from those trainings, disciplinary action against employees that engage in conduct that falls short of expectations can all be really relevant in defending claims where vicarious liability has been alleged. And what does enforcement look like now? Well, we've got a new positive duty to prevent sexual harassment, which is imposed under the Sex Discrimination Act. We've also got inspectors from the Australian Human Rights Commission that can help enforce that, which basically means there is a better awareness now about individuals' rights under the Sex Discrimination Act. We've also got increasing damages awards. Last year, the record award was $305,000 in damages, with a substantial component of that being tax-free, and better cost protections. So if an individual wins their claim, they can get some costs back from the employer. So what this means is that there is a better uptake of claims for breaches of the Sex Discrimination Act where they otherwise were not brought up. Now, finally, in workers' compensation land, if an employer does not follow their internal policies in managing that employee, that can kill the reasonable management action defence. And that has generally been relevant for employers up until now because it impacts on your premiums. Now, there has been a premium freeze for the next 2 years, so that may not be relevant for you right now, but it will absolutely be relevant in the future. And we haven't got time to tell you about it today because there's a whole presentation to talk about that. But we've got this new jurisdiction coming out of workers' compensation amendments, where an employee more or less has to prove they have been bullied or harassed where their claim is denied. And an employer's policies will no doubt be relevant in that process. Sorry, I'll skip to the next slide. Now, what we've got here is basically our view of a policy checklist, and obviously what policies you require in your business are going to be specific to the industry you work in and the kind of clients that you service and the work that you do. But here's just a broad idea. We've got bullying and harassment, workplace grievance, and code of conduct, which are your 3 seminal policies that Safe Work cares about when they're investigating a psychosocial safety complaint. We've also got drug and alcohol testing, which is really relevant for those doing safety sensitive work. We've got information technology, which helps protect things like your IP and employees doing things on the internet that they shouldn't. And we've got specific work health and safety policies, which of course are going to apply depending on the work that you do. Now, we haven't got time for questions. We will come back to anyone who has left us a question. We would also like to pose a couple of questions to you. The first one is, which contract clauses for you cause the most friction? And are your policies sufficiently comprehensive, current, known, and enforced? That's all from me. And once again, Warwick, you're on mute. Okay, Warwick's still on mute. There is some kind of IT problem here. So anyway, I will sign off on behalf of everyone. Thank you so much for coming and sticking around. We will be circulating our slides and a recording of today as well if you want to look back at it. And for anyone who asks questions, we will come back to you after the seminar. Thanks so much for your time, everyone. Bye.